Okay, let me go ahead and like I said, when we recessed last night, courts had an opportunity to ponder the issues that were presented yesterday in terms of the admission of lyrics or the exclusion thereof. So to that extent, the court has considered the state's motion in limine to admit evidence of lyrics, the state's supplemental motion in limine to admit evidence of lyrics at trial, the state's amended particularized motion in limine to admit evidence of lyrics at trial, the opposition to the state's second supplemental and motion in limine to admit evidence of lyrics at trial filed by and on behalf of Mr. Kendrick and argued by Mr. Weinstein, as well as Jeffrey Williams' motion in limine number 2, 1, and 2 to motion to strike, as well as Mr. Shart's oral motion, and the court will also consider it for any other lyrics that may be sought to be admissible in the trial of this matter. Specifically, I have considered the arguments of the state as well as the arguments of the defense. I'll kind of go through those in just a second. The state has argued that this particular gang lyrics or evidence is admissible for several reasons. One, to show actus reus or mens rea, or other offenses under 16-14-4, 16-15-4, or 24-8-801D2 alpha, 28-8-801D2 bravo, 24-8-801D2 echo, and 24-8-804 B3, specifically, as well as 16-15-3, 16-15-9 for those particular relevant purposes. The court is well aware that there are several gatekeeping functions that the court must perform in determining logical relevance under 401, presumptive admissibility under 402, and legal relevance under 403. The defense has argued that use of these particular, the admission and use of lyrics, poetry, or artistry against Mr. Williams or any of the other named defendants as appropriate in this upcoming trial would be a constitutional violation, abuse of discretion, too prejudicial and unconstitutional based on the provisions of the U.S. Constitution as well as the Georgia Constitution, and that moreover, using these lyrics, poetry, artistry, speech against Mr. Williams and others would be racist and discriminatory because the jury would be poisoned, prejudiced by these lyrics, poetry, artistry, speech as the same as unlawful character assassination. The defense has asked me to exclude these particular lyrics, poetry, words, speech, artistry from the indictment and exclusion from testimony and evidence pursuant to 24-4-401, 24-4-402, 25-4-403, and 24-4-404A, as well as the constitutional provisions as set forth in the Georgia and U.S. Constitutions. Mr. Williams, as well as others, have asked this court to further suppress any video, photographs, posts, or images that deal with these particular lyrics, words, speech, poetry, artistry, to be excluded from trial as well in total, and that these videos are protected speech as articulated by the same aforementioned provisions of the Georgia as well as U.S. Constitution. And as I mentioned, these arguments the court's going to apply as to all parties, not just the ones that argued yesterday, Mr. Steele, Mr. Sharp, and Mr. Weinstein. The court also, in considering this particular ruling, considered under the provisions of 24-1-104, which is the conditional admissibility or screening determination that this court may make. And I'll cite from our code, preliminary questions concerning the qualifications of a person to be a witness, the existence of a privilege, or the admissibility of evidence shall be determined by the court subject to the revisions of the subsection B of this, and that's on relevancy, depends on the fulfillment of a condition of fact. Court shall admit it upon or subject to the introduction of evidence sufficient to support a finding of fulfillment of the condition. So if I have to look at A before I can get to B, but it also mentions that subject to the revisions of subsection B of this code section, in making this determination, the court shall not be bound by the rules of evidence, except those as respect to privileges. Preliminary questions shall be resolved by a preponderance of the evidence standard. And then B covers the relevancy of a condition of fact so in this particular circumstance, the court's just making a preliminary admissibility determination. Of course, anything that the court may rule upon at this point in time will be subject to a complete foundation being met and may be subject to other additional objections. But the court has considered, in terms of 104, states 1 through 20, as well as defendants 1 through 4. Mr. Weinstein, thank you. We got the PowerPoint you presented yesterday. We also have D2, D3, which is, I believe, the drive, and D4, presented by Mr. Steele, and D4, which was the chart that Mr. Steele circulated for the courts and parties' consideration. So I've considered that universe of conditionally admissible evidence for my consideration on the ruling, on this particular ruling. The court has also further considered in making this ruling the commonality of specific lyrics as they relate to the issues of mens rea and actus reus. Also, the court has also considered that, depending upon the proof presented in this case, and that YSL, its and testimony that may be relevant of the gang's organization and/or strength would be relevant. The court has also considered that these particular statements are being offered to show the elements of the offenses and not the threat or conduct is not being prosecuted, but these particular lyrics can be associated with different things that the court mentioned that the state has proffered in States 19. As it pertains to the First Amendment assertions raised by Mr. Steele and Mr. Weinstein and Mr. Sharp, under the First Amendment. The court has, in fact, considered Carpenter among other cases that were cited for the court's consideration yesterday, and that these lyrics, that rap lyrics are relevant, and they must, that the court must conduct a 403 balancing test, which it shall. In terms of the First Amendment analysis that Mr. Steele suggested I needed to conduct, I do have to conduct that, and I have conducted that in looking at the use of the statement, or is it being admitted for a proper purpose. I know that Mr. Steele argued very eloquently yesterday about it being character or improper character, propensity. It's not being admitted for improper characters that would fall under, the court would certainly screen it under certain other evidence standards. And the propensity argument that was made yesterday, this, as mentioned by the state, this evidence is not being admitted saying that Mr. Williams and any others did these things before, so they do them again. So I'm dissuaded as to the propensity argument. As it pertains to the issue of mental state, argued under 27-7-404B, expert witnesses, if qualified, may draw conclusions about intent as long as they don't state that this is the defendant's intent. So to Mr. Matthews, and your continued argument about that, and Mr. Steele as well, as long as those experts do not cross that particular line, those particular things would be relevant. I've also considered United States versus Smith at 918 F. 3rd 825 that assuming a foundation can be laid, certainly, and if it's within this can of expert testimony, that certain terms or technology, or terms and or symbols or signs may be appropriate and relevant, giving meaning to gang determination. And then, so for those particular reasons set forth therein, the court is going to admit for the limited purpose thus far, the state's request to apply the evidence statute as written. I'm going to conditionally admit particularized lyrics, and those lyrics are found within States 18. There's 17 sets of lyrics. They're from pages 41 through 49 of States 18, 41 through 49 of States 18, submitted for the court's consideration yesterday. Those specific statements, the court will admit, I'll conditionally admit those pending lyrics, depending upon or subject to a foundation that is properly laid by the state or the proponent that seeks to admit that evidence. And to that extent, I have also considered the Taylor, White, Torres, and the Commonwealth versus Knox cases, and I find this to be that the conditional admission of these particular lyrics are proper. I would just ask the state, or just remind the state if any other lyrics are sought to be admitted, that I'd have to go through this same analysis, and if you would do so prior to us putting a jury in the box, that would certainly be helpful.